Hi YouTube, this is VidHead85 and I want to talk a little bit about something here that happened in New York. Everybody knows that June 24th of last year, the state legislature approved the Marriage Equality Act, which was a really big piece of legislation for Governor Cuomo, and he passed that, and it was able to pass in the upper chamber, the Senate, Republican-dominated legislature, 33 votes to 29. The four Republicans voting were Senator Releasy of Rochester and Monroe County area. He's been redistricted also. There is also Steve Saland, Mr. McDonald, and my senator, which I've been redistricted out of his district more than likely. I think Maisie Arts will be mine, and I will vote against him for Amy Ogletree come November. So those are the four Republican senators that voted yes on marriage, and 29 of 30 Democrats, of course sans Ruben Diaz, voted for the act, and that was able to pass. July 24th, first same-sex weddings happened in city halls around the state. Some of the county clerks do not want to issue such licenses because they feel as if their faith does not allow them to do so. However, I feel that if you are a town registrar for weddings and you do not want to do that, you should get another job, because that is your job. Simply is to provide the licenses and sign them. So anyway, that happens July 24th. Then July 25th, the New Yorkers for Constitutional Freedoms, led by Reverend Dwayne Motley, decided to file a lawsuit in hopes to overturn the law. Now what he does is he goes to an area that is, I believe they had it in his hometown, or it was a place that was mostly known as a conservative area, and the ruling with which Judge Wiggins had written regarding the Marriage Equality Act, alleging that the open meetings law was violated because of the caucuses that they held in secret, which I did some digging around and found out that the open meetings law does not apply to caucuses. The Republicans would often have a caucus, and the Democrats would have a caucus as well. It would be a closed-door caucus, and therefore, Mr. Motley said that it violated the open meetings law, and no one could have access to the senators, either opponent or pro. So Judge Wiggins gives them an early victory, and an appeals court, mid-level, I believe, appeals court, or intermediate for that matter, that's how they usually say it, an intermediate court found that the open meetings law was not violated by those caucuses, which in fact, again, you know, when I looked, it did not say that caucuses were subject to the open meetings law. But they also said that it was rushed hastily, and that the message of necessity was not at all necessary for that. Now, a message of necessity is usually given for negotiated bills such as the Marriage Equality Act, and the message of necessity can come from the governor for any reason that he deems fit. So if a governor were to pass a healthcare bill, they could pass them, they could negotiate it, hammer it out with the leadership, and the assembly would pass it, then the Senate would pass it, or either it would either originating body would pass it to the other body, and then they would ratify it. And that message of necessity could be, hey, we want to pass this health care bill to provide more New Yorkers with health insurance. We're passing this Medicaid expansion bill so that we can have more, so that we can take advantage of the recent upholding of Obamacare. Simply, a message of necessity can be for any reason that the governor says, and the appeals court, I believe, I didn't read about the message of necessity, but I'm pretty sure that they held that the message of necessity was in fact valid, as it was the governor's, and it states that it could be any reason that the governor deems fit. So I was really happy about that. I'm pretty sure that the New York State Court of Appeals may agree with the lower court. It's still running through. What the New Yorkers, for their own constitutional freedoms, want is simply to overturn that law, because if they find that any part is unconstitutional, it has an inseparability clause which says all of it, if any part be found unconstitutional by a state court, all of it would be found unconstitutional, and that's what they wanted. Now, they picked July 25th, 2011 to file this suit because they just want to piss on our parade. But of course we didn't have that. Also on that day, I went to the first mass wedding in Niagara Falls, New York, which was great. However, of the 46 couples that got married, I saw when we were doing the legwork for passing this bill. However, most people who will take advantage of a bill will never fight for it. So that's just how it is. And it was basically for me, so that I can marry whatever guy I would like to marry, and I won't be told that I cannot have a marriage license with this man who I want to spend the rest of my life with and is irreplaceable to me. So basically, I'm really glad about that news. I am sure that it will continue through if the New York State High Court of the highest court in New York State, which is the New York State Court of Appeals, if they should hear it. I will definitely let you know, and I'm sure that their ruling will agree with the lower court because of the fact that the open meetings law is not subject to caucuses, and the message of necessity should stand, as it is one of those things that the governors can do, just like in Mississippi when the governor pardoned those individuals, and the Mississippi Supreme Court held that the pardons is about the governor showing clemency. Although I feel that the pardons should have been thrown out, but that is what the governor can do. So you have a great day, YouTube. Let me know what you think about this. Do you think that the High Court of Appeals will uphold this ruling? I believe that they very, very well will. Or do you think that they may choose not to hear it altogether? You know, that is always an option, which I believe most high courts tend to do that. They may just dismiss it by not hearing it, or something like that. I don't know how the state Court of Appeals will run, but of course, as with the Supreme Court, they must agree to hear it. So let me know what you think about that, and have a great day, YouTube. Rate, comment, subscribe. Later.